Ladies and gentlemen, we come to the last part of my presentation, but before I go to 108, because I will not be long on 108, I will explain to you why. I want you to mark in your rules a few places. That is not, it's not only having a relation to the subjects I'm here to tutor you about, but it's applicable to that plus the wider range of dispensing law. I would like you to give ample time and attention to Rule 1, Sub-Rule 3, the overriding objective of the rules. If you are going to be asked maybe a question that will require from you to state the contents of a rule, it might be that one. But I am not prone to do that. Maybe one of the other lecturers will propose such a question. And for me, it's not necessary that judicial officers should know the rules by verse and title. You have the book there. You have the book as a reference. It's not necessary. There's a few of us that can be this academic animals that can quote standing a lot of cases and a lot of references, etc. I know one such a person in Namibia, but he's already retired. But that's not necessary. That is only there to impress people. We don't need to impress people. You have your reference works with you. When you have a problem, stand down or ask a question in court, counsel to address you, opposing counsel to address you, sometimes on their feet, then stand down and quickly revert to the rules and to the applicable law. As judicial officers, we have the advantage of being addressed by legal practitioners. And most of the times the legal practitioners try to do their work, and they do their work. And they can give you a lot of handy references. So, and then I also want you to mark with a small mark, a dot or something, Rule 6. In the High Court, when you institute an action, you are required to fill in a form containing the particulars of Rule 6. And when you, as on behalf of a defendant, defend the case, you are required to complete that particular form prescribed in Rule 6. Your duty as judicial officers, and a lot of us sometimes live in a dereliction of that duty because of time pressure. And then belatedly we want to do it. But take the time, take the 5 minutes per case. Whether it's a paper file, whether it's an electronic file. And look at the form uploaded as requirement for Rule 6. And look whether all the blanks are filled in. And if it's not filled in, then apprise the legal practitioners and require from them, where they can, to complete it. Because the form becomes very relevant later on if one of them withdraw. They are supposed to, in terms of Rule 44, 7 or 8, I think, 44 sub 7 or 8, to when they withdraw, to have the notice of withdrawal served by the Deputy Sheriff on their client in terms of Rule 8. On e-Justice, it became very easy for them just to upload a simple form of withdrawal without even a return of service. And they are off the e-Justice system. So even if you then make an order in court that they should properly withdraw and only will be regarded as withdrawn after complying with the requirement that their notice of withdrawal should be served on their client, they are not there to read the order anymore because they are cancelled on the e-Justice system. This is now still an inherent problem with which they try to solve, but until now it's not solved. But then the requirements in Rule 6 become important because sometimes no one, believe it or not, can trace this either defendant or plaintiff after the attorney's withdrawn. I have a case now where the attorney time and time come to court and say, but should I still remain on record because I withdrew, I was never paid for my services, etc. But the notice of withdrawal was not served. Tough luck, ladies and gentlemen. Tough luck also on the poor legal practitioner. If they did their work in terms of Rule 6 properly enough, we would have had a manner to trace this particular litigant. But most of the time, it's a concert of absurd errors that lead to it there, that when they withdrew, you cannot get hold of their client. So be strict on the compliance concerning Rule 6. What mark with a red dot, sub-rule 4, 5, 6, and 7. I'm not going to read it. You can read it yourself. Mark sub-rule 8. It's the most important part. Sub-rule 8 of Rule 6. Sorry, 7. Yeah, the next one, 7 sub-rule 8. Thanks. Then we all know about the service and the requirement of service. We are not going to conduct and spend time on Rules 10, 11, and 12. You can read it. I just want to caution from practical experience. How many of you in your courts took notice thereof that your clerks issued process from, say, a neighboring country like Zimbabwe or South Africa in terms of Act 27 of 1994, the reciprocal services. Be very inquisitive, and there's a reason for that. If you can, at present, arrange your affairs in your court not to rely on service in terms of, especially Act 27 of 84, it will be good. An opinion that is not, in law terms, maybe a recent opinion, but it's already an old opinion. It was given in 2012 from the Minister of Justice, Chief Legal Advisor there, which after a lot of research found that they could not trace or detect that there was ever a formal reciprocal agreement between Namibia and South Africa, which underlies that act. They couldn't find record or evidence thereof. So be careful. It go to the next act. It's not yet deliberated on by our courts of law until today. That the next act is Act 28 of 1994. The Civil Judgments Act and registration thereof from designated countries. When I encountered the problem on Act 27 of 1994, I started to raise the issue in court, but there was no answer until now, and no research done, but there's a few cases that rely on that, and I expect now the legal practitioners acting in those cases to investigate the matter. Is there a reciprocal agreement between our two countries, verified by our parliament, concerning this, the Civil Processes Act? If there's not one for the previous Act 27, why would there be one for 28? Time and time again, the judicial officers in the lower courts will find that with their clerks, a foreign judgment is registered. Then there's a certain procedure, service again, locally. Now let me tell you, sitting in a court in a default scenario, I for one will not grant a judgment or execution on a foreign judgment after I was apprised of the lack of an agreement in terms of Act 27. I will not execute on a foreign judgment in Act 28 until I'm satisfied that there is an underlying reciprocal agreement ratified by Parliament. And I doubt it very much. That bring to question certain running matters in the courts that go at the moment either on appeals or reviews to the High Court, and I have knowledge of those matters. I also have knowledge that some of the legal practitioners are going to raise this particular point. Because if the Act is not properly in place, although promulgated, but it is not underlined and underlined by the requirement in Section 2 and 3 of both those Acts, then should we assume jurisdiction over that? I just want to warn you. I cannot give you a case now that's reported on. I just want to apprise you of it, because if such an issue start to come to the fore, I, for instance, is one of the type of people that I want to divulge that knowledge in a small group like this, because you act in matters like that. Ask the questions. Ask the questions. If someone come for execution, or ask the question, you are entitled to. Why do you submit that I have jurisdiction derivated from that process? Go to the specific section. Ask them. We don't have the time sometimes. Ask them, especially if you have a defendant matter. Research and come and address me. Then we will get clarification in future. This is one aspect You will find several of these type of aspects in your working environment. Talk to your colleagues. Talk to other people knowledgeable in the law. Raise the question. If you have conversations with legal practitioners in private, then preferably not those with similar cases in front of you. Ask them. Maybe there's someone that knows about it. Maybe there's proof that there is such an agreement. I couldn't find it until now. But pose the question. Make people around you alive to jurisprudential questions. While I'm at that point, and while I touched on jurisdiction and it's outside the ambit mostly, also the following. Don't just assume jurisdiction in your courts because the parties allege that you have jurisdiction. Especially where there's a defendant that is not a Namibian, not residing in Namibia, or not Namibian registered. Ask the deeper questions in the particular case to the particular counsel appearing in front of you. And here I can give you an example, and next year you will all know to what I refer. We have a multiple actions going on at the moment in the High Court concerning a very specific matter. I got one of the matters, and then it was a flash in the pan. One night I was thinking a lot about it because it's very eminent people in that case. And it came back to jurisdiction. How could a court of first instance, which was the High Court, have assumed jurisdiction on the underlying legal dispute ever? And if a Namibian court couldn't have assumed jurisdiction or entertained jurisdiction, how can a court at a later stage, where reliance is placed on a certain case that was not completed because of certain negligence, and damages is claimed, how can you entertain that? Now, there will still be an address, but some things we usually accept on face value. Be inquisitive. Be inquisitive, even if both the parties are represented. We are lawyers, we are trained lawyers. We are there to enhance jurisprudence in our country. And do not allow everyone, and especially not any South African, to raise in your court and tell you that they have a better process and a better application of law in their country. They don't. We are already at the stage that this country and its jurists, practitioners, judges, senior magistrates cannot be ignored. Build on it. Build on it. Trainees, I'm very passionate about a lot of things in life. When we look at the substance in a default setting and a 108 setting, when we look at substance of pleadings in front of us, have a good knowledge of Rule 45, especially 45.5, 7, and sub 9. And sub 9. That is the basis from what appear in front of us. Also in a default scenario. I'm going to 108 cursory in a moment. Before I come there, I still cannot remember the case I referred to this morning to concerning service, but I will go and have a look and give the name to you tomorrow, because I want you to read that case. In your 108 notes, you have seen the references to Standard Bank of Namibia Limited versus Shipila. I think the reference is there. I don't have the 108 guidelines in front of me. No. Okay. It's in some other is it not in the other document that I gave you? Okay, but in any event, I will give you two references of cases that I want you to read. The one is presently still on appeal to the Supreme Court. It is Standard Bank Namibia Limited versus Shipila. You will find it on the e-justice system under judgments. The neutral citation thereof, I'm just going to read the last part. It's 2015 NAHCMD 281, but the case is also reported in the Namibian law reports under the following reference. That is now Standard Bank versus Shipila. It is 2016, Volume 2, Namibian Law Reports, page 476. 476 in the High Court. In short, the case discusses the Rule 108 procedure and what a lot of, especially banks, try to do. They try to attach a form to their particulars of claim, which will give them the right, according to them, to not only get a default judgment, but together with the default judgment, an order to execute on the property. This case explained beautifully to you why it should not be done, why there is a difference between the default procedure as primary procedure and then secondary, the procedure under Rule 108. And it explained, like the next case that I'm going to mention, the judicial oversight function. This is an important case. Probably, if you are going to get a question from my side concerning Rule 108, the next case, Futeni Collections, I'm not going to read it all, Futeni Collections versus the Dana, the Namibian Law Report reference, 2015, Volume 3, Namibian Law Reports, 829, High Court. That is a judgment from Judge Masuku. It also explains the notion of a primary home. It also touched on what is touched on by Acting Judge Miller in his judgment in the Standard Bank Shipila case, why there is two processes and why there should be two processes. That, in a nutshell, will tell you a lot about most of what you need in terms of Rule 108. there is one issue in 108 that I specifically want to discuss with you, and that is Rule 108, Sub-Rule 4. Rule 108, Sub-Rule 4. If you ever sit in a Rule 108 court, which is a separate court from the residual court, start to, because it's not done strictly at the moment. I understand that because there must be ample time for people to start to know the 108 processes. There's still one of the 108 processes, another matter that will in the next year also go to the Supreme Court. It's a matter that I must first finalize in the High Court. I know it will go to the Supreme Court. That is about the retrospectivity of Rule 108. You might smile about it. I sometimes smile about it. But there's a big push from the commercial banks to say that Rule 108 should not apply to bonds that were registered prior to 2014. That will be a next question for the Supreme Court. But I want to draw your attention to Sub-Rule 4 of Rule 108. And I'm going to read it now, and that it say, the execution creditor, and now you will see the tie-in with the two judgments that I have given you, and why it is a separate process, the 108 process. The execution creditor must make an application in terms of Sub-Rule 1, brackets 1, brackets B, within 30 days from the date on which the return referred to in Sub-Rule 1A, that is a return that there's insufficient movable property to satisfy the debt. I go back, the return within 30 days after the return referred to in Sub-Rule 1A has been filed by the Deputy Sheriff in terms of Sub-Rule 3, or, it's not an and, or, if application as provided for in Sub-Rule 1 Sub-B has been made and that application is dismissed by the court, the date on which the application is dismissed by the court. What does it say to us? And it's not in practice. And Ms. Mokomela also bear knowledge of that. After the nulla bona return concerning movables, it is seldom that the practitioners or the execution creditor bring an application within 30 days. I don't know why. I don't know why they do not heed the obligatory provision. It's sometimes 90 days after the matter. Sometimes longer than that. If we look at the process at that stage, they already knew that there is not enough movables to satisfy the judgment. Why should they not heed the 30-day period? They must bring it within a specified time, and that is 30 days. don't do it, why I think they don't do it. In most of these cases, the judgment debtor was not part, obviously, to the default proceedings. Now he's faced with a deputy sheriff coming, looking for movables. Not enough movables is fine. It's seldom that a judgment debtor will have enough movables to execute on, to pay the principal debt. If he had that kind of money, there in the first place would not have been a judgment against him, because he would not have defaulted. But now we sit with a practical problem, because judicial oversight, the Act and the rules bring the following practical problems, also practical problems, not only solutions to the beer. Sometimes the movables of the judgment debtor was attached, sold on a forced auction, knowing it will not be enough to satisfy the debt. Now the person don't have movables. Now they come after the immovable. Oversight in that sense, again, will require from you to have a bird's eye view on matters. If the parties on the Rule 108 application phase, it's a judgment debtor come and say, and they are usually unrepresented then. That is why they don't take issue with the 30-day period. They are unrepresented. They file a statement or an affidavit saying, but it's my only home, it's my primary home, I live so much time already in it, I have so many dependents on myself, and I look after the children of my children. We will not have a livelihood, no place to stay after this. But it remained the right of the judgment creditor to execute, because that was agreed upon, that was bonded. Where the bird's eye view from the judge come into play is then having the people in front of you, requiring them. Is there a policy that will pay out in the immediate future? Do you have shares in a company or a membership in a CC that you can sell? Most of the times the deputy sheriffs don't look at that as movables, but it is. Then the inquiring mind of the judge and the judicial overseer come to play, trying to establish whether there is a hope, a reasonable hope and prospect to satisfy the judgment debt without declaring the immovable property executable. I personally think that and I would raise the question, if a judgment creditor did not heed the rules and did not bring an application within 30 days, it will be difficult for me to declare the house or the bonded property executable. If they wanted it so badly, why didn't they follow the rules? It brings me to another point. All of us know it. We do not talk a lot about it. We all know, and I don't think there's anyone in this room that can tell me that he or she have read and understood every clause of their suspensive sale agreement, or their bond agreement, or their home loan agreement. You sign it because you want the loan. You don't have the money. If you start to query the bank about this and this, they say, take it or leave it. No one say it hard enough. Is that not compulsion? To a certain extent. We can say, no, it's not compulsion, because you, as the judgment debtor, had the opportunity to say, but I'm not going to sign it, I'm walking out. The same as in the default scenarios. That is why I want you to have compassion with the undefended names in front of you, and be strict on any plaintiff and how their papers are drawn. Because there are rules. If you don't read every clause, how will Maria Guaguses, without any formal education, which learned from her auntie and her oma or grandmother to read and sign her name, how reasonably can we be smug and say, I come back to what I said earlier this morning, beware of what you sign, subscriptor caveat. We need compassion, and there's place for compassion in the rules and how we apply the rules. And the place for compassion come in also in 108 proceedings. If no one ever have cared about the judgment debtor, and the judgment debtor stand to lose their only abode, be as strict as possible. It's the business of the banks to make money in mortgages. And for mortgages, the in duplum rule does not count. They make money. You buy a house for 10,000 and over 10 or 20, 30 years you pay 50,000 for that house. They make money. Look at all their year-end results. But then when they are in front of you as judgment creditor, be strict on them. Be strict on them in terms of the rules. And be compassionate to the judgment debtor. How would Anna Guagusep has even understood what she signed? 5, 6 pages fine printing. How can I reasonably believe that there was an employee of that banking institution that took 3 days, that's the minimum requirement, to explain all that to an uneducated person? Now the whole thing went into a circle and they are in front of you as a judgment debtor. Be sympathetic to the judgment debtor. But if the judgment debtor have another farm and 2 other houses, don't be sympathetic. Don't be sympathetic. There's other things that they can sell. I am talking about the majority of the population in this country that need our compassion, judicially applied. Don't be smug because you sit on the bench and just declare things executable. If the bank must wait for 2 years for a policy to pay out, let them wait, let them cry, let them whine until it's paid out. That is judicial oversight. But if this big judgment creditors come to your court after 90 or 20 or 120 days without an explanation bringing the first application for execution, chase them out. Even if it is not raised as a point by the judgment debtor. You have the rules, you have the terms of the bond, apply the rules then strictly. You were not within 30 days. Sir, Madam, Corporation, there you go. Then 30 days. 30 days after the first application for execution was dismissed, the judgment creditor should file another application. Thank God that is the last application. Even if that application is heard in a year, they must file another application. What I ask of you, be strict. Sometimes strict requirements to comply with the rules are good. That's why you are judicial officers. We should never forget our roots. We are all human. We all need money. We all rely on the society around us. You cannot, as a judicial officer, even if you think so, you cannot exist in isolation. You cannot. It is your duty to be compassionate. It is your duty in terms of the Constitution to be fair to all litigants, even the undefended one. And then there's a further procedure going down, then it's referred to the magistrate courts. Then I don't know what happened. I think, unless some of you can convince me otherwise, thereafter, they will, after reference to the magistrate court, after there's 2 failed applications in the High Court, not much will be done. I don't want to say it outside. I don't want to say it in public. But if big financial institutions sometimes must suffer losses, let them suffer losses. Let them suffer losses. If they suffer losses on the blood and the livelihood of our indigenous people, which they elect to contract with, let them suffer losses. Apply the rules strictly. I did not sit as a judge in a 108 court. Did you sit as a research assistant in a 108 court?
Yes, Judge.
Am I correct to say that seldom the application is brought within 30 days?
Yeah.
Why do we condone that?
Normally, the legal practitioners would file this long affidavit explaining what happened between the order that was granted.
So there is a type of condonation application.
Yeah, they'll always file a condonation and explain their way through and through trying to get condonation.
Okay, they can still do that. Look whether it's acceptable or not. Obviously, the courts until now entertained some of those condemnations. But I hear what you say.
You see the word dismiss, for me a dismissal, it's like, I know, stop playing.
Luckily, this is still young jurisprudence. jurisprudence. It will still develop. It will still develop in future. You will sometime get a strict approach, which obviously will be taken on appeal, because it's the money, it's the commercial conglomerates that have the money to do that. They will do it, because it's a big part of their business. Look, I'm not against, understand me, because I'm taped, and I don't know where all this will be, will be played again, but understand me, it's not, I also have a bond. I also have a vehicle under hire purchase. I also need the banks. I just say that even if I have a bond and even if I have a hire purchase or something like that, obviously I'm not, according to my oath, I will not favor the financial institution if I see what happened in society around me. I see that. We all observe that. 108 is one example of where the judiciary came about, and the JP in 2014, and even before the amended rules, but subsequent to 2011, abolished the procedure that registrars gave default judgments and execution orders. That is good that it happened. That is good that it happened. There must be judicial oversight. But it happened now in this particular frame of Rule 108, judicial oversight, execution of immovables. And you could assess me from yesterday already, I would like you as judicial officers to be so compassionate in all your dealings with the litigants in front of you and in your contact with people in other spheres of our life. And always remember that the judiciary is one of the three legs that underlie our constitutionality. But we are not entitled, although some of us might believe that, we are not entitled to put ourselves on a throne and to look down on other people. We must be the example to our brothers and sisters that do not have the advantages we had to educate and to study. It is for them and out of them that we are where we are today. That is our roots, never forget it. Don't be dismissive to anyone. Entertain any person that ever come into your circle of contact with respect. I want you to apply it on your judicial work. Now, you will see that I'm not going to go through the rules part by part. You will have now, in these two cases, you will have a very expedient summary and reading material. For me, it's senseless to repeat something that is written to educated people. It's senseless. For me, it makes sense that we as the judiciary make ourselves available to converse with our colleagues in the judiciary and on the magistrates court level. That makes sense. It's some of our trainees said to me, it's concerning to divulge knowledge, to expose myself and the other judges that give training and even those that do not training to you as we are accessible. If there is problems, if you want to discuss, be free. Go through the channels. If you don't want to go through a lot of formal channels, you know my name, you can get my telephone number. You are as welcome as any legal practitioner to make an appointment and to come and have a discussion with me about anything, even about farming. Sometimes you will see if you have such an attitude, you become overworked. You have this eyes that I have, but it is rewarding. We do not, and I will not always entertain immediately or within a week a request. But we will make time, even if it's after hours.
They won't know how to do it.
Is there not still, at least in name, an office at the magistrates court level that where a magistrates court clerk, say in this, let me call it in the civil division or the civil stream, are entitled to give guidelines to lay litigants, say after a matter like that, that they can approach some of the officers there, not the magistrate, for guidelines.
It's become a full-time job.
I-
It's a problem.
Yes. It brings me to the point. Then we should work to attain it in the next financial year or the next financial year, to appoint just such a person at every level, magistrate court, high court, we don't talk now about the Supreme Court, that there's such an officer or such an office accessible. That will be, for me, a nice to have. It will make me, when I die in 50 years, to die with peace. But then, from your side, on the magistrates court level, when you are in conferences, talk to your superiors or the people that arrange it, that they institute such a post.
There are not even enough clerks.
I know.
For the real work, the people just.
But that is why we must create the culture between the people we are appointed over with, and ourselves, to just this culture, to share, be compassionate, divulge. Do that. Because what are they asking you? They don't ask advice that you must think out. They are mostly asking, what's the procedure to follow? Give them the procedure. I don't know how, but now it's your problem. Go and ask a lawyer. If they say they cannot afford a lawyer, I always have this practical experience. How in a community can people sometimes not get guidelines if in a prison we see that there's a lot of homebred lawyers in a very, very smaller community. You sometimes need a person. I have a beautiful old lady in mind at the moment. She's a secretary at UNAM. I will not say her name. She was one of the litigants in front of me in the beginning of the year. She's only a secretary there, but experience have trained her a lot. At a stage, her lawyers dumped her because she couldn't pay. And she was very, very furious. She appeared in front of me, but she must get a lawyer. And I told her, Miss X, please, for this case, from the bench, you don't need a lawyer. You are versed. I can hear you, how you talk. I see that you are not afraid for that attorney. That is what you need to do now. The next step was a witness statement. Write it. Write your story. Have it typed. Go to the High Court. Have it uploaded. I will not allow technical objections to that. Write your witness statement. Upload it. You can do it. You know what happened? At the end of the day, she appeared herself in her case. She cross-examined. She did a lot of reading. She cross-examined, sometimes feeble, sometimes with a flash in the pan. She surprised me on one point especially, and also the two attorneys sitting there, and she won the case. And when she started with this litigation last year, I did not think this thing will go anywhere in her favor. It happened, and to a certain extent you are allowed for an undefended, like for an undefended accused, for an undefended litigant, you are allowed to give them guidance in court. Just see to it that you do it on record. That if the other side want to take issue therewith, that there is a record. Don't do it in your chambers, but advise them in court. Stand the case down until the end of the row. The attorney will jump up and down because they have another appointment, they don't want to work after 5, even if it's 7 o'clock. Call the matter last and have that discussion on the record. If you see that they cannot afford, they will not get, but they want to proceed, you are not giving advice outside the rules. You explain them the rules to them. That is compassionate. And you get them to read. She has become a very ample student of our rules and the law. And a week or two after the case, I still had my previous researcher there. Nicole come into my office. She said, Judge, Miss X, yeah, she brought you a chicken. And I said, is the chicken alive? She said, no. It's slaughtered. She said she must give you something. I said, please tell her to go and cook it for a family. I cannot accept anything. But it's a lovely response. I had such a response from a very eminent businessman in one of our towns recently, which also he couldn't pay the high-priced lawyers. It became too much. He had a certain concern. He said he cannot go on. I said, why can you not go on? If you are entering into major commercial why can you not go on? I convinced him that he could go on his own. And he went on and then settled on very favorable terms with the other side. Sometimes it's just necessary and it's just required from a compassionate judicial officer to ignite the flame of interest in your own case. A lot of people can understand that. You are surprised. I'm also surprised. I hope you don't report me too negatively to the JP. But I think we understand each other. You are all responsible individuals. I again invite you for tomorrow, but I will have to report whether all of you were there, and if some of you were not there in court, whether there's valid excuses, then convey it to Lorraine Kluter. But I expect you, if we don't have lectures tomorrow, I expect you to be in court. I will try, with the cooperation of one of two legal practitioners, to make it a learning experience. I still had documents that I wanted to discuss with you, but while I was busy yesterday and today, I thought you will find it on the system when you prepare. And you know that I will not ask you any questions concerning repeat that or say what's the contents of that. You will get from my side this type of questions. Apply your knowledge.
Are they going to be, until what time will they be in court to attend the 108 proceedings?
Look, it's not 108 tomorrow, but I have the residual court roll tomorrow. Default judgments. My court start at 10. So if you can be there from, say, 9:45, you all know where the SADC building is.
So basically they are going straight to SADC.
Yes.
Coming here, they are going straight to SADC.
Sorry?
They are going straight to SADC.
Yes. Look, I'm not coming here at 9. If you want me to, I will do it, but come straight there. Come straight there. And if you want to, I will even make it easier accessible. I will try not to call a lot of cases tomorrow, but some cases that will have a practical learning experience in it for you. Then I will finalize the role. After the completion of the court process, which I will promise you will not take longer than 1.5 hours. Then we don't have to come back. Then in that courtroom, you can break for 10 minutes. I will take off my Batman dress and come back to you, and we will discuss the issues there until 12:30. Or if you want more time, I don't mind. Then we conclude the lectures. Lorraine, will I make it now difficult for our... I don't think the personnel will be necessary, the video recording personnel will be necessary in court tomorrow. I don't think we should do that. For the hour discussion afterwards, you might decide whether they should be there or not. I just think it's a bit of it's impractical to come back here for only an hour. It may be longer, but I think we can have our practical discussion after court. But I'm open also to all the students. You must tell me, if you want us to come back here and have a discussion, I will do it. I just think it's unnecessary. Do we have a consensus about this? And then I will also give you this case that I still cannot remember the name. I remembered it for 4 days, and now I don't remember it. But luckily, I can go and look for it. Come again? I don't know. I don't know. I rather give you the correct reference. I want to thank you all for being here and being here on time and listening. And tomorrow, when we conclude after the court, if some of you were not, can do it now or tomorrow, if some of you were not satisfied of how the proceedings was conducted when I was supposed to give you a lecture, you can tell me. You can tell me. If you would have preferred a different format, you can tell me. It's also a learning experience for us, how to conduct this training in future. I'm just very careful not to be too pedantic, because we are all grown-ups.
Judge Savage wants to say something.
Yes, Ms. Savage? Okay. Okay.